Hi, my name is Vanessa, and I have been working with Mr. Davis since 2014. I actually found him online. I was researching someone to take on the DCFS case that I had at the time when I was dealing with DCFS. I think that's what I like the most about him, is that he's very patient and he's calm, he's collected, and he knows that he is confident because of what he does, and his work shows. He's a different type of lawyer, and he's one of a kind.
Good morning. Welcome to CPS Office Hours. I'm Attorney Vince Davis, and today we're talking about something many parents in CPS cases find confusing and frustrating: the role of the child's attorney. Are they helping or hurting your case? The attorney may have more influence than you think. Today, I'll break down who they are, what they can do and can't do, how they impact your reunification efforts, and how you can work with or challenge them strategically. Please consider donating or joining FightCPSSchool.com if this information is helpful to you. All right, segment 1. Who is the child's attorney? The child's attorney is appointed by the court to represent the child, often called, quote, minor's counsel, unquote, or children's counsel. In many states, like California, the child attorney has duties under the law. First, the attorney must interview the child if developmentally appropriate. Next, the child's attorney must advocate for the child's wishes if they believe that the child is old enough to make those types of decisions. I hear many times, which I believe is to be appropriate, is that the minor's counsel will tell the judge, my client wants ABC, but then tell the judge, but it's my belief it's in the child's best interest to give the child XYZ. Next, the child's attorney must make recommendations based upon the best interests of the child. Now, this is a very important person in the courtroom, and I think too many attorneys don't, or too many parents don't consider what the child's attorney is doing or not doing. I have a case right now where the child's attorney is involved in the case and is going to my client's house, speaking to the child, and investigating herself, which in this particular case I think is appropriate. There was one thing I was a little concerned about, the child's attorney speaking to the parent while they're at the house. The child's attorney usually has to have my permission or the parent's permission to, interview my client without me being there. Under the California bar rules and most states' bar rules, a minor's attorney can't talk to the parent without the parent's attorney's written consent. So if a child's attorney comes over and wants to talk to you, you should probably say, hey, I can't talk to you without Mr. Davis's permission. Let's email or text him to see if he's okay with that. And, tell the minor's attorney you'd love to talk to them, but you just need Davis's permission. There's an important distinction that I want you to keep in mind. Children's attorneys are not your attorney. They do not work for CPS, even though it may seem like that to you, but they often support CPS findings, unfortunately. Many years ago, when I first started practicing in this area of law, I was a court-appointed attorney. talking maybe 30 years ago, 35 years ago. Under the model that I came in under, a court-appointed attorney would represent the parent, the relative, or the child. So I actually have several years of experience representing children in CPS cases. Under current models and subsequent models of court-appointed attorneys, that doesn't happen. If you're a parent's attorney, you're a parent's attorney. If you're a minor's attorney, you're a minor's attorney. It's a little unfortunate because when you only represent one class of person in the CPS case, you kind of get, I don't know, locked into looking at the case a certain way. But when you represent children and parents and relatives all at the same time, on your caseload, gives you a better perspective. When I was an attorney, and it depends on the person's experience and background. When I was a child's attorney and a parent's attorney, I had the unique situation, I think, of being raised by my grandparents. So I was always, uh, of the opinion if the child can't go back to the parent, why can't the child go back to the relative, the grandparent? And so I think that when an attorney has those different experiences, it comes out in the representation of children. All right, segment 2. What are the child's attorney's legal duties and limits? Well, first, they must keep the child's statements confidential. They must investigate the child's safety, health, education, and welfare. They can file motions, cross-examine witnesses, and call their own witnesses and present their own evidence at the time of any hearing or trial. In some cases, they will argue for placement, services, or even termination of your parental rights. The legal standard in California, governed by Welfare and Institutions Code, I believe it's 317. You can Google that, and it gives a legal explanation of what the child's attorney is supposed to be doing. Child's attorney must also, or should also, file reports. Sometimes they act like a second CPS lawyer. Segment 3. When the child's attorney works against you, which happens in many cases, they will do this when they believe the allegations and push for foster care or adoption. The child's attorney may rely too much on the social worker's reports and not do their own investigation. When I was a child's attorney, the judge that I practiced in front of required you to personally go do a home visit or visit the child at foster care, which gave you a unique perspective on what the child's doing, how the child is being cared for. And sometimes when you're alone with the child at their home or placement out in the backyard or something, or sitting on the front porch, they tend to tell you things that they might not otherwise mention. The child's attorney may also sometimes never talk to the child. And I think that's a bad thing, but it's their decision whether they speak to the child directly or not. The child's attorney often influenced the judge more than the social worker. I did a case maybe a few months ago, and the social worker's attorney and the social worker were arguing against me. I ended up winning the case, but I have to say that it wasn't all my brilliant arguments. The child's attorney in that case joined me and made arguments of his own. This particular gentleman, I've known him for several years, and children's attorneys that are experienced, they're not afraid to go against what the social worker is recommending, and that's always a breath of fresh air. Sometimes parents say the child's attorney never spoke to the child but told the judge she wanted to be adopted. Um, I don't think that if that is true, I don't think that that is appropriate. It's kind of a misrepresentation, but you never know. I mean, you never know when a child's attorney really speaks to the child. Um, Most of the cases I'm on, um, I don't personally know, but I've worked with a lot of these children's attorneys. And if they make the representation to me as a licensed attorney in California, an officer of the court, that they have spoken to the child, I usually don't have any reason to believe otherwise. All right, segment 4, what you can do strategically in your case. Well, first of all, remember, document your child's real wishes. You may have recordings prior to the case, drawings, letters. Okay. Ask your attorney to file a motion for minor's new counsel if you believe the child is biased or negligent. Yes, you can file a motion for a new attorney. And one of the things that doesn't come up a lot, but you and your attorney have the right to object to the child's attorney who's first appointed to be the attorney for the child, but you have to do that right at the beginning. Otherwise, you have to make a motion to remove that child's attorney. And a lot of times, these things aren't discussed with the parent. Your attorney, if your attorney is experienced, may have dealt with this minor's attorney before and may advise you, hey, we don't want this particular attorney because of whatever situation. You should track whether the attorney has visited your child under 317E excuse me, of the Welfare and Institutions Code. Remember, I told you earlier, the judge that I first started working in front of doing these cases, he required that. In every hearing, he required you to give a report about what was going on with the child. You should also gather statements from therapists, teachers, and counselors who support your reunification with the child. Try to build a coalition around your child's voice. All right, segment 5 this morning. When the child attorneys actually helps. Some attorneys actually do their job well. They visit the child regularly or have one of their social workers visit the child. They advocate for siblings to stay together. They oppose CPS when they believe reunification is best. If this is your case, be supportive and respectful. But don't make the mistake of always trusting the child's attorney. Children's attorney, like everyone else in the case, have their own objectives, their own agendas. And you may think that the agenda is to get the child back with you, and you may be incorrect. As a parent, you can share resources. You can invite the child's attorney to observe during visits, perhaps your interaction with the child, and provide proof of progress of your case plan. Now, don't forget, you shouldn't be talking to the child's attorney unless and until you have your attorney's approval. All right, segment 6 this morning. Pitfalls to avoid. Do not try to speak to the child's attorney without your lawyer. Do not threaten or insult the child's attorney. It will be used against you either affirmatively or secretly. These children's attorneys are people. They have the same strengths and weaknesses as other people. Do not put your child in the middle to argue your case with this attorney. And this is the golden rule. Let your actions, documents, and progress speak louder than your frustrations with the system. Okay, let's wrap this up. The child attorney can be your greatest obstacle or a powerful ally. It depends on the case, the facts, and how you respond. If the attorney is not doing their job, don't stay silent. Document it. File a complaint with your attorney and ask for a child's replacement. Child's attorney replacement if necessary. I'd like everyone to join the fightcpsschool.com to learn how to advocate, organize, and build a defense team. And if this live stream helped you, please consider donating. I'm Attorney Vince Davis. Stay calm, stay tactical, and I'll see you on the next office hours, which will be tomorrow at 6:30 a.m. Before we sign off on these office hours, let me see if there's any questions in the comment section. Okay, from YouTube, Tony Tiger says, good morning. Here from Wantana, New York. Hope I pronounced that, Tony. Also from YouTube, Yash. Good morning. Ken from Sacramento. Hey, good morning, Ken. I'm going to be up there, I think, next week on a hearing. Tony from YouTube also says, can a parent be in the room with the child while talking to the attorney, or is that not allowed? Tony, in 99% of the cases, that's not allowed. When I was a minors attorney many years ago, and parents or relatives wanted to be present with the child, I sometimes agreed to that for many different reasons. Okay, Betty Joe from Facebook says, good morning. Hey, Betty Joe. Can the child's attorney change placement if they've already appointed a placement involved? The answer, Betty Joe, is simple. Yes, they can. They can do many things on behalf or claiming to be on behalf of the parent, of the child. Betty Joe says, can the child's attorney change placement prior to the TPR? The child's attorney can't make that change in placement, but can recommend the change in placement and join either the social worker or join the parent or join a relative with respect to changing placements. Okay, so they do have a lot of power. Most judges, in my experience, listen carefully to what the child's attorney says. They don't always agree or rule in favor of the child's attorney, but the child's attorney, in my opinion, has a significant voice in most of these CPS cases. So if you want to gain the favor of the social worker, don't forget to talk to your attorney about gaining the favor of the child's attorney, important player in the CPS case. They get to ask questions at any hearing and trial, and they can be a powerful ally or a powerful enemy. So keep that in mind. Okay, I guess that's the only questions we have for today. Anybody else has any questions? Go ahead and post it quickly in the comment section. You know, just to mention something, I was in a county yesterday where the child's attorney on my case was a parent's attorney in another case. So in some counties, they still do have that old setup which they had in Los Angeles, where court-appointed attorneys can represent anyone on the case. In my opinion, that's a pretty good mix, because the attorney gets to see the respective sides and issues related to each case from a parent's perspective or a child's perspective. Now, whether they're on your side, that's a whole different issue. All right. Okay. No more questions. I want to thank everybody for watching, and we'll see everyone tomorrow on my office hours. Have a good day.
So I really encourage anybody that's going through this to seek Mr. Davis's services, because he will help you in the long run. So I mean, words can't even express how happy I am with his services, and I just want to thank you, Mr. Davis, from the bottom of my heart.